I know there's a time limitation, but I just wanted to share few thoughts on these controversial issues on the international exhaustion. My friend from Singapore has already mentioned you about the TRIPS provision, Article 6, where it is clearly stated that the dispute relating to the international exhaustion or any kind of exhaustion will not be dealt with by the dispute settlement body of the WTO. Why this situation came during Uruguay round? Because the member countries could not arrive at a decision. So therefore, even today, there are two schools of thought. Largely, the developing countries are in favor of the international exhaustion, but the developed countries, they are not in favor of the international exhaustion principle. So the world is divided, but he has also given the list that what are the countries which are following the national exhaustion, what are the countries like European Union, they follow the regional exhaustion, and there are again few countries like India, Japan, which are following the international exhaustion. But here again, there is a point of difference. There is a school of common law and there is a school of which follow the other system, like where they have the statute. So India, as has been rightly pointed out by my other speaker, through 107 capital A small b, through a statute we have accepted the principles of international exhaustion. Japan, although it has been following the principle of international exhaustion, but there is no statute dealing in the Japanese patent law. But like India, as my friend has mentioned, Singapore also has a statute which accepts the international exhaustion. Japan does not have any particular statute. But in Japan, in July 1997, there was a BBS case, and under that case, it was clearly stated that the particular facts of the case were the company which had a patent in Japan as well as in Germany, they used to import, they used to sell their goods in Germany. So one person, they purchased the goods from the patentee company and exported it to Japan. So in Japan, there was a parallel import. So the question was whether it is an infringement or not. So the district court gave judgment in favor of the patentee, but the Tokyo High Court did not accept the infringement issue. But finally, when it came to the Supreme Court of Japan, Supreme Court said that it is not a case of infringement because the person who sold the goods to the person who exported goods to Japan, there was no stipulation that the goods cannot be exported. What finally the Supreme Court has said, unless there is an agreement between the parties, excluding Japan as a country where the goods can be imported, and there is a explicit indication on the goods itself that they cannot be imported into Japan. So these two cumulative conditions, unless these are fulfilled, the goods can be imported into Japan. So therefore, although there is no statutory provision, but there is an implied license, if the two conditions are not fulfilled, the goods can be imported into Japan. But if you talk to the Japanese authority, they say that we don't follow international exhaustion. We only follow parallel imports. Okay? So though both the terms parallel import and international exhaustions are interchangeable, but still they maintain that they do not follow international exhaustion. So this is about Japan, but then I also want to mention the position which is changing in United States. In the Curtian judgment in case of copyright, which was delivered on March 19, 2013, there also, as per Article 109 of the Copyright Act of United States, where the Supreme Court upheld that the geographic